day. Okay. Well, it's astonishing to consider that in this day and age, with all of our technology, information delivery systems, and real-time communication, that consumers still struggle to access the legal system. Pro se litigants struggle because they lack information, even though the information is there for the taking. I Googled Florida divorce and got over 16 billion returns in about a half a second. It's astonishing, it's overwhelming, way too much information. So I filtered that down a bit, and I used Florida divorce information. Still, I got over 7 billion returns in about 0.4 seconds. Again, too much information for anyone to take in. And a lot of the information is contradictory, outdated, unreliable, and much of the information is so general that it isn't helpful at all. So the searcher can read every single page of every single website on that first page of Google and wind up not knowing anything you didn't know to begin with. Learn nothing new. It's hard, it's frustrating, it's mind-boggling. Technology is a tool, but it's not the answer. People use tools. People are the answer. What if we could be the filter for all this legal information? What if document preparers could not only prepare documents, but also provide consumers with the information that they need and want? The good news is that we can, and you probably already do. Whether you have a formal policy as a business policy to give legal information to your consumers, your customers, you probably do so every day. When a customer, a potential customer, a consumer walks into your office, calls you or emails you, he probably isn't window shopping. He's got a problem, and he's hoping you can fix it or help him with it. But document preparers are not even allowed to select forms. How is this pro se supposed to know what to file unless someone helps? Is he really supposed to read all those pages on the first page of Google, those 7 billion websites? Is that what he's supposed to do? Or spend his days and nights at the law library trying to find the answer to his one single question? Some pro se litigants think that the clerk of court is there to give them legal information and explain procedure. No. We know, most of us know firsthand, and our customers tell us if we didn't know firsthand that that's not the case at all. Clerks of court rarely give out any real helpful information because they can't. They fear for their jobs. Depending on the clerk, the county, the circuit, and maybe the weather, a clerk of court may give some guidance. But they usually won't or can't. Why? Because of that supposed fine line between legal advice and legal information. But in fact, there's no fine line. It's easy to know what's fact and what's advice. It's actually nonsensical to pretend that it's difficult to tell the difference. A fact is a statement that can be verified in some way. A fact is something that truly exists or happens. Advice is an opinion or recommendation offered as a guide to action or conduct. Think about this. These are very different things, completely different ways of thinking and communicating thoughts. So I doubt that they are often actually confused. I know that when I say,
you should wear your seatbelt, then I'm giving advice. And when I say Florida law requires people to wear seatbelts, that's a fact. And if I say the first step in eviction for non-payment of rent is to deliver a 3-day notice to pay or quit, that's a fact. But here's where the games begin. Every driver knows that he's supposed to wear a seatbelt. You have to know it to pass the driving test or you'll get a ticket. I've been a landlord since 1984. It's old news to me that you have to give a 3-day at the beginning of an eviction. I know that, but unless you know it, unless someone told you or you found out some other way, you have no way of knowing. I learned years ago, but there is no landlord course for beginners. There's no, new landlord license course. So they don't know. And so what a lot of people will do, landlords included, will go ask the clerk of court. Now, they may get handed a packet. They may be told, well, Google it. They may, a lot of things. Some of the circuits will have those forms on their site. They may be told that. But they usually don't get a lot of help. And the reason is, like if the customers or the consumer says, my tenant won't pay his rent, what should I do? He's unlikely to get an answer from the clerk of court. Or maybe even a document prepared because it sounds like the answer has to be legal advice. It sounds like the answer is going to be, you should give your tenant a 3-day notice, which is true, but that should statement is what you need to get rid of. So, if you answer that the first step in eviction is a 3-day notice to pay or quit, see Florida Statute Chapter 83, that's a fact. No one can fault you for that. That's a fact. It is wordplay. It's semantics. And we can work with it. People ask all the time about which procedure or form to use for their desired outcome. We can't select forms for them, but if they know what they want to do, but don't know the name of the form or procedure, in my opinion, it would be wrong to refuse to answer. The consumer has a problem, or he wouldn't be talking to a document preparer. To say, sorry, can't answer that, is acting like the clerk of court. And we can answer. Answer with a statement of fact, not a should statement. All Florida attorneys have standing to initiate a UPL investigation. Think about that one. We are not regulated by the Florida Bar. We are not attorneys. Attorneys in some aspects are our competition, yet they can report us for supposedly engaging in UPL, even though we don't have anything to do with them. A scenario where an attorney cries UPL because he's losing to a pro se litigant is doing nothing more than gamesmanship. An attempt to hamstring his opponent by taking away the one tool he has, the document preparer. And sadly, it works. At that juncture, a prudent document preparer would sever the relationship with the pro se litigant and address the UPL investigation directly. It's a risk we take. Every occupation has risk. Roofers, firefighters, electricians, pilots, chauffeurs, truck drivers, farmers, trash collectors, and construction workers are among the most dangerous occupations. Anyone working in one of those occupations could die on the job. A business risks their money and time hoping that the returns exceed the outlay. Our business is unique because legal document preparers could be subjected to a harassing UPL investigation or even fined or face incarceration just for doing our jobs, just for trying to assist a customer. In fact, in the big picture, Our risks are minimal, providing we plan ahead and take precautions. A roofer knows how to walk a roof, to wear a safety harness if the pitch is too steep. Firefighters have safety gear, which they must keep in good working order at all times, so that when they run into the burning building, they have their gear to rely on. We also have tools to mitigate risk. Use them. The Florida Supreme Court, the Florida Bar, and the Florida Commission on Access to Justice has been discussing and debating various initiatives for as long as I can remember to increase consumers' access to the court system. Despite their efforts, there has been little actual change or improvement since we formed FALDP in 2010. Document preparers are completely overlooked as part of an official solution. Every time I see a newspaper article, bar article, press release that discusses the need for private sector innovation to increase citizens' legal access, I write a letter to the Florida Bar. I tell them, we're here, we're part of the solution. If I get a response at all, it's usually along the lines of, don't call us, we'll call you. Besides being dismissed and ignored, we're harassed. The threat of an investigation is always there. We hang back in the shadows and are not as aggressive in promoting our business as we might be. We fly under the radar and try not to draw attention to ourselves. We second guess our every move, lest we might somehow do something that a UPL committee or a lone attorney decides might be engaging in the unauthorized practice of law. More than one FALDP member has closed up shop, specifically because of the threat of unfounded UPL allegations. Until the day we demand that the state of Florida recognizes that document preparers are here to stay, that document preparers provide a sought-after service, and we have earned our place in the legal system, we as business professionals will remain marginalized, vulnerable, and ineffective. Today, I ask every FALDP member to stand with me and demand what is ours. Demand the right to pursue our livelihoods without interference. Demand the respect that each of us deserves. Actively transcend the challenges we face by faithfully serving our customers. And because of their gratitude, seize what is ours. We create positive change in consumers' lives every day. We help those who have given up, who don't know what to do, and who cannot possibly afford an attorney. We make Florida a better place to live, despite the zealots who would have us fined and imprisoned. Come with me out of the shadows, bask in the sunshine, fly into the radar, stand with me to seize what is yours. Transform the fear into a mission to continue your work in the light of day. Stand with me and never look back. Thank you.